So this is the final topic, which is called automatism. Now, actually we've talked about this topic a lot in terms of insanity, as these two topics come together. Insanity is always attached to automatism. Indeed, most of the pages in the middle of this handout are identical to those exact words on the insanity handout. So this should be a much quicker presentation in terms of just looking at a couple of extra new bits of detail, but most of this is contained in the initial insanity handout. Okay, so in terms of application and essay questions, again, these two topics come together. So the focus will be just picking up how to apply automatism with a few key bullet points, which we'll come to in due course. Okay, so at the top of the handout, if you'd just like to put there the second name for automatism, which is non-insane automatism. Again, that's not new information. When we talked about insanity, we talked about that also being known as insane automatism, and this is the second form of automatism, known as non-insane automatism. Now, once you've told the examiner once the insane and non-insane label, thereafter refer to the two defences as I for insanity, A for automatism, and they will understand exactly what you're trying to explain there. So, automatism then, or non-insane automatism. So this is something that's been governed by the common law, so Parliament have never looked at this defence, and it can provide a defence to people who commit crimes while suffering from a malfunctioning of the mind. So that's the same as insanity, some seizure, some difference in the workings of the mind. So, however, this has to be due to an external cause. The defendant this time is not insane, so there is no internal matter which triggered the malfunctioning, but there is some other reason why D was unable to control his actions at the time of the crime. So, key features of the defence: the actions of D must be deemed involuntary. So D must have a lack of control, and that must be due to an external cause. Second bullet, D's actions must represent muscular movement without will or volition. So D is not choosing to act as he did, but because of the external cause, he's having to act without will or volition. The defendant may be aware of what is happening, but incapable of preventing his bodily movement. And finally, it must be considered, due to the fact it is an acquittal, a one-off accident or novelty type of event. So the structure of the handout, stroke the defence of automatism: number 1, definition; number 2, degree of control, so how much control must he have or not have; reflex actions; then the main body of this handout, exactly the same as insanity: dissociation, diabetes and sleepwalking, which are covered by both defences; self-induced conditions, i.e. self-induced automatism; and burden of proof. So the definition of the defence of automatism was defined by Lord Denning in Bratty versus the Attorney General in 1963. So Parliament have never defined this, so it's not medical, and it's something that just came from the courts. So this is the definition. So this is the only bit really on the handout that you need to know almost word for word if possible. So an act which is done by the muscles without any control of the mind, such as a spasm, a reflex action or a convulsion. Or an act done by a person who is not conscious of what he is doing, such as an act done while suffering from concussion or while sleepwalking. So very old definition, totally non-medical, but that's the definition that's been there since 1963. Okay, so question: what problems exist with the Denning definition? which is AO2. Number 1, it is outdated. So if you see there the inclusion of sleepwalking, sleepwalking now is predominantly deemed insanity. It can be automatism, but certainly it can be considered more so insanity in the UK. So number 1, outdated. Number 2, as I previously referred to, it's not medical. And in fact, actually, if you went to a doctor and asked a doctor to define the meaning of automatism, the origins of the word automatism is to do with a type of epileptic seizure. But of course, epilepsy is deemed insanity. So it's completely not medical. Automatism is something that the judges have come up with. The third issue with automatism is it's very narrow. For example, it's very difficult to establish, very difficult to prove and be successful as a defence. And another example of a problem going back to that definition, the definition states that D, or the person who is raising automatism, must not be conscious. However, that's not truly accurate. One of the most famous examples of what is automatism, or what would amount to a successful plea, are the bees, something I've mentioned in class before. The bees. So I'm driving home in my car, driving perfectly normal, a swarm of bees fly into the car, so I lose control and I veer onto the path, which is a road traffic offence. That is the most classically explained example of successful automatism. So I've acted from an external cause beyond my control. But actually in that example, I am not unconscious. So what we're saying above is the definition is not very good. It's not medical, some of it's outdated and some of it just doesn't make sense. Right, so that would be for an essay, which is probably less likely, more likely application. So in terms of application, examples of what you're looking for, these are classic examples that have existed in the case law. So examples of automatism, concussion, so where you concussed and in some kind of seizure. Anaesthetic, so where you're given anaesthetic from a doctor, but it has a funny effect or it hasn't quite worn off yet and D commits a crime. Hypnotism, the swarm of bees, dissociation we've covered, diabetes we have covered, the malevolent passenger. These are all examples that I've got from the previous case law. The malevolent passenger would be if you're driving and your passenger suddenly starts to attack you, which causes you to cause a crash or a road traffic offence. That would be an external cause, bringing on a malfunctioning of the mind. Stroke, blackout, blinding pain. So that's it really just about. Those are the examples you're likely to see in the exam where D might want to raise automatism rather than insanity because those are caused by an external matter. Okay, finally on the intro, what happens where automatism succeeds? Predominantly, and this is not always, because self-induced is a separate category, but for normal automatism, D will be acquitted because D is deemed to not be at fault. When you think about it, if it's something external and it's a one-off, then D is not at fault and he should be acquitted with no criminal conviction. The problem with that is sometimes the defendants, as we will see, it's not always appropriate to acquit. Sometimes some of these defendants should be given some type of custodial sentence. So this is a contrast with insanity. Insanity is all about protection of society. So making sure that the most dangerous people are removed from society, whereas this is quite the opposite, because D will ordinarily be acquitted where it succeeds. We'll come to self-induced, it's the last paragraph after the DDS section. So after the definition, we've got degree of voluntary control. We'll be able to summarise this certainly next week, where we just get to the key points that you need for application. So all this will make straightforward sense. So the degree of voluntary control. The defendant, we know, must have a loss of control by the mind, which must render the movement by his muscles. So the movement of the muscles must be deemed completely involuntary. The automatism must prevent the defendant from forming either the actus reus or the mens rea for the offence. It can be both. So in short, what we're looking for is that D had a lack of voluntary control. The problem is, of course, what do we mean by a lack of control? Complete control, reduced control, and to what degree? So this is something that's been problematic for the courts. So what are the problems with the required lack of control? First bullet point, it's been undecided whether a complete lack of control must be present or whether reduced. So first bullet point, is it complete lack or reduced? That's something the courts have questioned and struggled with. The second bullet point, the problems with control, whether you're looking for a lack or just reduced, is it's very hard to prove this evidentially. There is no dividing line between consciousness and unconsciousness. So for example, I've personally seen people in epileptic seizures or diabetic seizures. The onset is where they start to lose control. So when they are perfectly normal, that's 100% in control, then 90, 80, 70, 60, etc. So even though somebody in the onset of a seizure might have 60% control, they are still semi-conscious. But how do you prove, looking at somebody, the defendant, whether or not they had a reduced or a particular level of control? So there's all sorts of issues here. Number one, what level of control are we looking for? And number two, when you've made that decision, how do you prove that? However, to go in terms of application, this is the way we'll take this forward. It seems overall, and this is the consensus of the courts, there are some disagreement, but this is what we'll go with, that for normal crimes, so not something that's not SL or anything else, just a normal bog standard crime with a full MR attached, then D must suffer from a lack of control. D might be aware of what is happening, but there has to be reduced control and a lack of consciousness to some extent. So in short, normal crime, reduced control. However, the second category, SL offences and driving offences, now why those two have come together is simply because the cases that have come to the courts have combined the two, but most road traffic offences are SL, vast majority. So if it's an SL stroke driving offence, the test is this: no control at all. So D must have absolutely no control over his body at all or appreciate what he's doing to any extent. So normal crimes, reduced control. SL and driving offences, complete annihilation, nil control at all. Okay, now I can give you some examples of that. For example, a normal crime, and you'll see this with the case law in a second, but for a normal crime such as criminal damage, let's say, so if a swarm of bees came into my classroom and in a panic I smashed a window, criminal damage is a normal crime. The test would be reduced control. I had reduced control. I had some control, still conscious and still aware of what is going on, but that could be a successful defence because theft, criminal damage, in this context criminal damage, is a normal full MR offence. The test is reduced. My control was reduced because of the swarm of bees. Second example, we'll stick with the bees. If I'm driving and I go onto the path because of the swarm of bees, that particular driving offence would be strict liability, so automatism would fail. Why? Because my hand is still on the wheel, my foot is still on the pedal, I have control. So automatism would fail this time. So with the normal crime of criminal damage, it can succeed because I had a reduced control due to the panic and the bees. But with SL, a driving offence, it would fail because I still had some control. Right, the last mini section, couple of lines, are reflex actions, which of course reflex actions are part of Lord Denning's definition. And this is another problem with the definition. So, reflex actions, these form part of the Denning definition of automatism. However, it now seems that reflex actions don't always form part of the defence. So it's another problem with the definition provided by Lord Denning, which is out of date, non-medical. So the case we need to use for reflex actions is a persuasive decision from Australia, the case of Ryan. The defendant was committing armed robbery and he shot and killed the victim during this robbery. Now, the defendant had been tying up the victim, who had moved and then startled the defendant, then causing him to pull the trigger, which killed the victim. The High Court of Australia, that should be, upheld the conviction and automatism failed. Legal principle, reflex actions do not form part of the defence. So this is an example showing that actually reflex actions are not part of automatism. Right, so however, what other cases suggest that reflex actions are included? Again, this needs to be reformed by Parliament. An example, the most famous example, as mentioned beforehand, the bees. The bees that came into the car, making the defendant drive onto the path, that is what we would call a reflex action. So what I'm suggesting there is reflex action can be part of automatism, but sometimes it isn't. The definition needs to be looked at, revised, reformed by Parliament because it's confusing. Okay, so going back to the degree of control, we have the SL and driving cases that have come to the courts. So just right at the side there, driving cases, SL crimes, no control. That's the test. If it's a driving case or a strict liability offence, no control at all for automatism to succeed. So if D was able to appreciate what he was doing or operating his actions to a certain degree, the defence will not succeed. D must have no control at all, absolute annihilation, obliteration, no control at all. So the cases that have come up before the courts have been SL but also driving cases at the same time. So Broom and Perkins, first of all, very similar these cases, so you just need to differentiate, and we'll do this on a gap chart next week. Broom v Perkins, 1987. So the defendant was a diabetic who suffered from a hypoglycemic episode. So if you remember from Insanity, that is where D has taken his insulin but failed to eat or failed to eat sufficiently. So the trigger is external, hence it's on this handout as automatism. So he was diabetic, he had a hypoglycemic seizure, but he drove home from work and he was observed driving most erratically on his way home. Sort of driving, braking, swerving, hitting at least one car. So D managed to get home. He had no memory of anything apart from the beginning and the end point of the journey, whereby his wife had presented him with a Mars bar as soon as he reached home to relieve his condition. D actually then handed himself into the police because he saw the damage to his car, so he'd guessed and put two and two together what had happened during this journey. So he handed himself in, willing to pay for the damage, but was charged with a driving offence, driving without due care and attention. Now remember, the test is no control. Automatism failed since there was evidence that D had exercised some control by swerving and braking in order to avoid other vehicles. The defendant had steered his car in a purposeful manner. So even though he wasn't fully aware and even though he was in a seizure, the fact that the car moved and successfully got home meant he had some control. The test is no control at all. AO2, is that a fair decision? It does seem rather unfair because this is a defendant who lacked culpability, was definitely in a seizure and handed himself in. So he was willing to pay for the damage and clearly had gone to the police station, yet he was convicted of the driving offence. So it does seem a little harsh. Second case, Watmore and Jenkins. So this is another diabetic hypoglycemic case. This defendant, very similar, was suffering from progressive hypoglycemia, which is how hypoglycemia sometimes comes on. It'll be gradual, it can be over hours. Sometimes it's much quicker. This time it was progressive, so little by little he was going into the seizure, feeling a little bit unwell and getting into the hypoglycemic episode. But he still continued to drive a further 5 miles before crashing. So he raised automatism. On appeal, automatism was withdrawn because, again, the test is no control. D clearly had control over his car, bearing in mind he still drove for a duration of 5 miles. And it was held in this case that there had to be complete destruction of control for the defence to succeed. And only where D was not really driving at all would the defence be successful. Of course, the fact that the car drove a further 5 miles meant that he was having some control. Automatism failed. D continued to drive over a 5 mile stretch, hence had exercised control. And what we're looking for is complete destruction. So if you just go back to your handout next to Broom and Perkins, the way I differentiate these cases, and students have done it for years and it seems to work, Broom and Perkins, hypo, Mars bar. So Broom and Perkins was the Mars bar case. Watmore and Jenkins, next to the name of that case, hypo, 5 miles. Hypo, 5 miles. So the next driving case was a reference case, AG's Ref number 2 of 1992. Now this was a defendant who was driving his heavy goods vehicle lorry, HGV, over 6 hours, where he drove onto the hard shoulder and crashed into a vehicle, killing 2 people on the hard shoulder. So he raised automatism since he'd been in a state of a condition called driving without awareness. Now this is a real medical condition, and it's a condition that's brought about by driving on long stretches of motorway with repetitive stimuli, i.e. this is where you're driving on the motorway, and if you've ever driven on the motorway, this is something that I can well appreciate. When you're driving on the motorway and you're just seeing the same lines and lines and lines of road, a number of vehicles all looking similar, and there's no trees, no normal way of driving, going around corners and stuff like that. So it can trigger kind of like a trance-like state where D is just seeing the same road, the same lines, the same cars. So they go into this condition called driving without awareness. So although they are driving, they are not fully aware of what is going on around them. So he raised this condition and raised the defence of automatism. The Court of Appeal held on the reference that it would not be available for reduced, impaired or partial awareness. Again, going back to the point, total unawareness is the only thing that would suffice. Hence, automatism should not have been left to the jury, which it was. So in this case, we're looking for total unawareness. So all 3 cases are showing the same point. Yeah. Okay. Broom and Perkins, no control. Watmore and Jenkins, we're looking for destruction, complete destruction. In this case, reworded it again, total unawareness. All 3 cases proving the exact same thing, it's got to be no control. Couple of issues relating to the above driving cases. How do the inferior courts view the cases and such cases alike? Well, what we've got here is 2 different lines of opinion. On appeal, every time, and indeed in these 3 cases, no defence, no defence, no defence, automatism fails. But in the inferior courts, every single case is showing a more sympathetic approach, a more sympathetic view. So all of these defendants had been acquitted, but then on appeal, the defence failed and was withdrawn. So what it shows is that the approach of the inferior courts is out of line with the appeal courts, showing an issue for reform. Okay, so what is the wider opinion in relation to these kind of cases, driving offences? Well, various bodies, the Law Commission, the Butler Committee 1975, and various academics have all concluded one thing: too harsh, too restrictive. To say that if your foot is on the pedal, your hand is on the wheel, even if you're truly in a seizure, automatism fails, is too harsh. Again, Parliament need to reform. Then in the draft Criminal Code 1989, which was the venture of the Law Commission, what was suggested there, which is realistic and fair, is a new test called the prior fault test. Number 1, did D know the likely outcome? And number 2, did D have effective control? This would be a less harsh test and would show that the defence could succeed. For example, if it was somebody new to the condition of diabetes, so they're not quite sure about their insulin, how much they can eat. Currently, automatism would fail, even if they were in a seizure, because the car would still be moving. Under the prior fault test, did the defendant, the new diabetic, know the likely outcome? No. And did they have effective control? Let's say they're quite into the seizure. No, they don't have effective control. The defence could succeed. So it'd be a much fairer test, much more realistic, and it would allow the defence sometimes if it was rightly deserved. So a good recommendation by the draft Criminal Code. That was 89, so the chances of reform are pretty slim. Right, okay, last couple of cases then before we get to DDS, which is the same stuff on the insanity. Handout, Hill and Baxter. So this is another driving case. D was driving his car over a substantial distance without any incidents, but then he mysteriously drove through a stop sign and crashed. Now he claimed it had been overcome by a mysterious illness and was unconscious. Couldn't name the illness, didn't really know what had happened, but he'd just been overcome by something and he felt unconscious at the time. So this is more of a case to prove the evidential side of automatism. On appeal, automatism was withheld since D had clearly still been driving and controlling the car. And we've said lots of times there it's got to be nil control. So it failed on that score, that he was still driving, he went through the stop sign. In addition, the defence has to be supported by credible evidence for it to have a chance of success. So it failed for two reasons. Number 1, he had some control, and more to the point, number 2, you've got to name the condition and have evidence, medical evidence, to support that. Then Orbiter, in this case, this is where the famous Bees quote came from. And actually it's the most famous quote ever of automatism, the Bees. Right, and the final driving case is the case of Woolley, which seems anomalous to the previous decisions. So this was a defendant, he was on the M62 in a long line of slow-moving vehicles on the motorway when he suffered a prolonged sneezing fit. And he crashed into a car which caused further crashes and a domino effect into lots of different cars and serious damage to those vehicles. Again, the inferior court, the magistrates, acquitted and automatism succeeded, despite the fact that D was still driving and he still had some control. We know from the previous cases above, no control, hence the defence failed. Suddenly in this case, of course it succeeded, but yet he still had some control. The divisional court agreed that attack of sneezing or a sneezing fit could constitute involuntary action and sufficient for the defence. So it did succeed. Now, so that is certainly out of line with the other cases. All the other cases, the defence failed, whereas this succeeded. However, if you look at the bigger picture, it can be justified. So question, how can the anomaly between Wooly and the other driving cases be settled? My answer to that would be, in all the previous cases, so the first two were diabetic, and the AG's ref, driving without awareness, driving over 6 hours, every single one of those defendants knew about their condition. So they had hours notice or plenty of notice, but yet still continued to drive. They didn't take a rest, which they all were aware of what was happening. So in other words, all three defendants, so Broom and Perkins, Watmore and Jenkins, AG's ref, all had a certain level of culpability. They knew they were diabetic, or they knew they were going into this zombie-like, trance-like driving state. So all three should have stopped, eaten, rested, etc. So maybe it's right that automatism failed for all three. However, to distinguish Wooly, he had no warning at all. His sneezing fit came on in seconds, and this all happened at the same time. So actually his culpability is much, much less. So therefore we can justify a different decision. Still confusing, but we can justify how this was decided differently. Okay, for the next couple of pages, 3 pages, it's the exact same information, word for word, on the Insanity handout. So I don't intend to record these sections. I'll paraphrase them in just a couple of minutes, but there is no reason for me to record this because we've studied this and gone through it many, many times in class, and we've even applied it last week. So I won't go through it in detail, just literally copy the information from your Insanity. It's the exact same section, and then we just have the last little bit to box off. So just to paraphrase literally very quickly, normal crimes, so non-SL, non-driving crimes, we're looking at examples such as theft, criminal damage, or any other normal crime. And we've got various categories that have come before the courts: DDS, dissociation, diabetes, and sleepwalking. So just to look at dissociation, just to confirm, into small comments there, dissociation is where usually it's a huge life-changing event which triggers a trance-like robotic state, which is medically known as a state of dissociation, covers both defences, insanity, automatism, extraordinary events and stress. I called in class a big trigger, that's a one-off event, that's classed as automatism, full acquittal. If the state of dissociation is triggered by a small, ordinary part of life, ordinary stress, that is the defence of insanity, as we saw on the previous handout. So for T, Narborough, Faulkner, Raby and Stone, just simply copy the notes from the Insanity, which will take you 2 seconds. We've gone through those and recapped a few times. Diabetes, the exact same section on the Insanity, so I'll just talk 2 seconds about this. Diabetes, of course, covers both defences, insanity and automatism, depending on how the seizure came about, which is ridiculous. It's the same seizure in effect, and it's the same cause, the pancreas isn't working. Depends whether D has taken or not taken his insulin, which is completely unjust, but that's how the law is. Hyper high insanity, cause internal. So the defendant hasn't taken his insulin, so the cause is triggered internal, hence insanity. Hypo low, automatism. Hypo low, you've taken external insulin, you've not eaten enough or not eaten at all, so that is classed as automatism. Case of Hennessy and Quick to illustrate, as we've gone through and recapped in class. DDS, the final one, sleepwalking, or medically termed as somnambulism. So these are things like sleepwalking, night terrors, sexsomnia cases. Can cover both defences, insanity and automatism. Depending on the trigger, whether it's an internal sleep disorder or whether or not it's a one-off trigger, stress for example. So sleepwalking has been an area of huge concern because sleepwalking, the question is, should it be insanity or should it be considered automatism or should it be both? Now internationally, the vast majority would agree sleepwalking should be automatism. Think about in the news, how many cases do we see of people committing really serious crime or crime at all whilst suffering a state of sleepwalking? The answer is no, extremely rare, and therefore when it does occur it should be a one-off acquittal under automatism. But of course the problem is the leading case in the English courts is Burgess. Burgess is suggesting that sleepwalking is covered by insanity, so that's a huge problem. And clearly the courts and the academics think that Burgess needs to be reviewed and reformed. So the problem is here, how sleepwalking being viewed before and after Burgess in the English courts. Before Burgess, the consensus seemed to be that the relevant defence was automatism, for the reasons I have just mentioned. It's a one-off, people don't tend to sleepwalk, or if they do, they don't tend to commit crime or serious crime. So when it happens, that should be a full acquittal. However, post-Burgess, i.e. after Burgess, the law seems to be that insanity is the relevant defence. And that's a problem. No doctor in the world would agree that insanity should be the relevant defence for sleepwalking. No doctor. In addition to that, Burgess creates a separate problem. There are two ways you can interpret Burgess. Number one, Burgess is suggesting sleepwalking is insanity because the cause was an internal sleep disorder. So just on this occasion, because it was internal. So if Burgess's sleepwalking had been triggered by stress, possibly it could have been automatism. The second way to interpret Burgess is every case is dealt with by insanity. The answer to that question I can't answer, nobody can. Burgess is unclear. Is sleepwalking always insanity, or was it just insanity on this occasion because the trigger was internal? Absolutely no clue, no answer to that, and therefore Parliament need to reform. Right, so the rest of the sleepwalking case is exactly as on the insanity handouts. So you just need to copy and paste that. Right, the last small little section of automatism and then we're done is self-induced automatism. This is where the defendant has brought about the automatic state and therefore the defendant has prior fault. This is very rarely a successful defence because the defendant was at fault and he could foresee his condition would reoccur. For example, the defendant feels drowsy, sleepy, but still continues to drive. Self-induced. RD takes his insulin, but fails to eat. Diabetic, knows it's going to happen, but feels ill and does nothing about that. That is self-induced. So something like the bees would be normal automatism. Self-induced automatism, which we've seen a few cases of those discussed before. This is where you would conclude, after considering normal automatism, that in fact it was self-induced, which is very rarely a defence. Again, applying this, there's only a couple of new bits on this presentation. We will do that next week and the week after, so we'll pick that up pretty quickly. So self-induced automatism is very rarely a defence. So an example to illustrate that is Kay and Butterworth. So the defendant was driving home when he became really sleepy and drowsy, but continued to drive, and then he fell asleep at the wheel, causing an accident. So he raised automatism. It was held that since Dee could foresee the likely outcome of his drowsiness, that automatism could not provide a defence. He knew he was sleepy, he knew what would happen, and therefore that could not be a defence. So that is showing, going back many years there, 1945, that where automatism is self-induced, it should not and is not a successful defence. So we have some specific rules for self-induced automatism, brackets SIA, which depends on the crime committed. And these are the rules. These are 99% identical to the Majewski rules. So actually, this is pretty much what we've done with intoxication. And indeed the key case we've already done as well, which is Bailey. So, self-induced automatism, here are the rules. We know a crime of basic intent is one that requires recklessness, so it tends to be a less serious offence. There are some exceptions, of course, but generally less serious. And the rule is as follows. If D was reckless, i.e. foresaw his condition, then there will be no defence. If he was reckless in ignoring his condition, he's already got the mens rea. E.g. exactly what was suggested in Bailey. However, if D can prove he was not reckless, for example the new diabetic, then he can have a defence because the mens rea is recklessness but D lacks it, for example if he was a brand new diabetic unused to his condition. Okay, just to write a couple of notes then, just to clarify and summarise this, because lots of words there. Where D raises SIA for a basic intent crime, it will fail. 99% of the time, it will fail. The same as Majewski. You knew about the condition, you knew what would happen, therefore you've been reckless, you've got automatic mens rea. The same as Majewski, yeah? So for example, a diabetic of 30 years, you've taken your insulin, you choose not to eat, you know exactly what will happen. That's auto-MR. You've got the mens rea before you even commit the basic crime. So with basic intent, SIA will fail. The only exception to that, which is the only different element to this, which is different to Majewski, is you've got a very, very small chance of proving the defence if you were not reckless. The only example I can come up with there is the brand new diabetic, newly diagnosed, and he wasn't sure what he could eat, what he couldn't eat, had he eaten enough. That's the only exception that can apply, and it never has applied. So really, in short, SIA, basic intent, will fail unless D was not reckless. For specific intent crime, the rules are exactly the same as Majewski. So just to step back a little bit, specific intent crimes are the most serious crimes, where the mens rea is intent only. D may well have been reckless in ignoring his condition, or likely seizure, for example, but that does not mean he's got automatic intent. He's been reckless, but intent is a higher level of mens rea. So the test is the same as intoxication. The question is, did D have the mens rea? Did D have the intent? If D lacked the intent, due to the automatic state, then the offence can be reduced to the lesser crime below, same as intox. Yeah? So again, a few notes. Specific intent can succeed, can reduce the offence if D lacked the MR, the intent. So just in summary, basic and specific, it's the exact same rules that apply to intoxication, apart from that bit there. That basic can succeed, very rarely, no cases of it doing so, where D was not reckless. But other than that, it's exactly the same. Basic will fail, specific can succeed if D lacks the intent. So the case which governs the section above is a case we've seen before. It's on the intoxication handout, which is the case of Bailey, 1983. So this was a diabetic of 30 years, so he exactly knew his condition and what he could eat and should eat, etc. Having taken his insulin, he failed to eat sufficient. He did have some water and some sugar, but failed to eat sufficiently, which he alleged brought about a hypoglycemic seizure. And he was charged with a serious assault on a man which turned out to be his ex-girlfriend's new boyfriend. Now, the trial judge had refused to allow automatism, self-induced automatism, to go to the jury at all. So he raised several defences, obviously intoxication as well. So the trial judge refused to allow automatism to even go to the jury. Court of Appeal held that that was incorrect and that SIA should have been left to the jury for them to consider and then decide whether or not it should succeed or fail. The Court of Appeal on the appeal did something really positive and set the rules above the rules for SIA. But the conviction in any event was held to be safe and therefore the conviction was upheld. So D was charged with 18 and 20, whichever. If you look at the facts, there were various reasons why any defence would fail. If you remember from intoxication, the evidence, the fact that he'd had sugar and water after the initial taking of the insulin, evidentially he probably did not have a seizure. It was impossible medically for that to occur so quickly. Secondly, of course, he goes armed with an iron bar, so whichever defence you're looking at is gone around with intent. So there are various reasons why the conviction was still upheld. However, the trial judge had been wrong to withhold the defence. The test for D was in D's knowledge. Did he foresee the likely outcome occurring, having not eaten sufficiently, and was that sufficient recklessness? So in setting the rules above, they created the Bailey exception, which is a bit highlighted, that it could only succeed for this type of defendant for a basic crime where D was not reckless, as they did not foresee the likely outcome at all, and therefore the defence could succeed. So in other words, same rules as intoxication, basic fails, and specific can succeed and reduce, but the Bailey exception was added, which is the only difference, where it can succeed if D was not reckless, i.e. new to that condition. So this rule has been upheld more recently with both diabetic cases C and Clark, 2007 and 9. Both were diabetics and both were suffering from hypoglycemic seizures, i.e. had taken their insulin but not eaten sufficient or eaten at all. They both were driving and they both continued to drive and they both killed pedestrians. Both were convicted on appeal since their conditions were self-induced. Both recognised their conditions but continued to drive, hence they were deemed reckless. So where it's self-induced, you know what's going to happen. You have to stop, take a rest, eat, but certainly not continue to drive. So self-induced automatism failed for both. So however, where the automatic state is caused by the defendant's self-induced intox, it's back under Majewski. So for example, if you go out and get really, really drunk, you're in a self-induced state, also you're in an automatic state, but automatism is not the right defence. So self-induced intoxication is the relevant defence. Finally, for an essay burden of proof, the defendant has to produce medical evidence to support his state of mind at the time. So he can't just allege a condition, he must have some medical evidence. The judge must then decide as a question of law whether there is enough evidence to even go to the jury. If there isn't, then it doesn't go into the court at all. It doesn't go to the jury's attention. The burden of proof then lies with the prosecution to disprove that the act was involuntary. So they have to disprove automatism. Where it does succeed, it will be a complete defence unless it was SIA, self-induced, where it will be ordinarily reduced to the lesser crime. So that's it in short. It's quite a short presentation. Just a couple of new bits to add at the beginning and the start of the defence. Middle bit's the same as we've done over the last couple of weeks. So what I suggest is you just do the new bits, which won't take too long, and then we'll pick this up next week and the week after and we'll apply it with a little bit of insanity, which will take just a couple of minutes on a defences only question, for example. So I will see you next week.